I think we need to make the language perfectly clear. I mean, other than the fact that, you know, from what you're saying, I understand what you're saying, but I think we need to be, I don't know how to put this. I think we need to include some additional language that I had said, the budget, whoever has budgetary control over the CRA funds should also, you know, not be allowed to, or abstain from voting, so that they have a monetary gain. They may not be making application, is my point.
I want a clarification on, it's my understanding, the reasoning behind this is that you're not supposed to do business with the agency that you're actually voting for a member of. And that's kind of the way this thing is. So how is it that we have members on that agency that are getting bids to do work within the CRA district, are being paid a fee to do this work? Isn't that the same thing as receiving a grant?
No.
Okay, tell me the difference.
The difference is, when you receive a grant, you enter into an agreement with the CRA. And you receive money from the CRA. That money then in turn may be paid to design professionals, contractors, suppliers, labor and material men. That does not constitute doing business with the CRA. The funds that are received by those various entities working for the grant recipient, they're not doing business. Now, there is potentially a voting conflict concerning those agreements. And for that reason, an abstention is required of the filing of the form and so forth, just as in any other instance where a vote may potentially lead to one's, inure to one's special private gain or loss. And thus, you know, and that goes on down the line. You might be a subcontractor of a contractor working for a grant recipient. That, to me, would be a voting conflict of interest, but it is not doing business with the CRA.
Well, if you're getting a deal on your profession, you're getting picked every time to do a job within the district, it seems to me like you're getting a little special treatment there. If you had a rotation where you had to either do an RFP or an RFQ, and you were selected as one of 3 or 4 individuals that were going to be picked to do a certain job, I can see that perhaps is not taking you a little bit out of the loop. But if you're the same one getting picked time and time again to do the services, to me it seems like it's the same thing. I mean, I might be wrong.
The CRA is not picking.
I think you're missing the point. I think what we're trying to do is tighten up the rules and regulations so that what Jimmy and I are talking about, things that have happened, you know, in past years, whether it was 10 years ago, 5 years ago, 2 months ago, doesn't happen. It's not right, it's unethical, and nobody's keeping track. Nobody, you know, it's, who is, you know, when the gorillas
Commissioner,
in
it is not unethical in accordance with the Florida Code of Ethics.
Okay, but we can set our own standards.
But
This city commission,
we're
no,
talking
I'm not,
about two
look, Frank,
different
I'm not,
things.
look, no, we're not. What we're talking about, I don't mean to get into an argument with you. I understand about the state law, I understand what the rules and regulations are, you know, in the law itself, okay? But there's nothing that says, unless I'm incorrect, and you can correct me if I'm wrong, there's nothing that says this city commission cannot set policies or anything that's more restrictive to make sure that people aren't doing what you said, aren't receiving a benefit.
Well, what you proposed did not have any change to the current circumstance.
Well, then who's minding the store then, Frank? I guess is my question.
There you go.
I don't understand the question.
You don't understand. Yeah, how are these things happening? Who's not keeping track and of these conflicts, and you know, who's supposed to be overseeing? You know, if we have a CRA board member that makes an application for a grant, okay, and then is voting for that grant and gets a direct benefit from that grant, which is not supposed to have the grant money because it's in direct conflict. So who's overseeing this is my question. Who's making sure that they're following the rules?
Well, I believe, if I may, that Jim Cosmas, for example, applied for a grant in the most ethical manner, thinking he's doing the right thing. He's serving on a board and he applies for a grant. And at the time, both the city attorney, the CRA attorney did not see a problem with that. And I'm willing to bet now that you still have attorneys who would side with Jim Cosmas in the case versus siding with giving back that money and remaining completely, going above and beyond what is required by the state. And I think then you just get into, well, do you want to be up against the Ethics Commission or do you not? And I think what the city is trying to do is to say, we don't want to have to go up against the Ethics Commission, because I believe that Jim Cosmas didn't do anything wrong. If we're using that as a particular incident, I mean, he applied for a grant just like anybody else in the CRA and abstained from voting. But what Frank is proposing is that we're going to take it a step further, so no member of the CRA can apply for a grant.
And understand that, I think, I was not involved in the Cosmos grant, but I was involved in the other grant. But I think a mistake was made. Let me say that I have had discussions with at least 2 other entities that find the same circumstance in their CRAs. I think it's something that was not clearly understood, but the circumstance has been corrected. But on the issue, and I think it's a completely different issue, of those who may benefit from CRA grants, but are not receiving CRA grants, what Commissioner Plaskett proposed was what, by my understanding, is presently being done. And that is when someone on a board has an issue coming before them that would might inure to their special private gain or loss, they abstain from voting and comply with the law. And there's nothing that prevents them from entering into that business relationship with the grant recipient. Yes, you could, in your grant programs, have a condition that that money, whether it be secondary, tertiary, or however far removed from the grant recipient, that no one receive that money, you can have that as a grant condition. But I would suggest to you that that's something that you want to go through the process with the CRA and have their input. But there's a provision in the CRA law. Number one, yes, that you have to comply with the code of ethics. But number two, it specifically provides that encouragement of private enterprise, that the law encourages with the rehabilitation or redevelopment of the community development, redevelopment area by private enterprise. So I think it is contemplated that private entities be involved in